Everyone, thank you for joining. We understand that some people are shuffling in, so we'll just give people a few seconds to join and then we will get started. Okay, let's get started. As I said, good morning or good afternoon, everyone, depending on where you are. Thank you for joining us today for this Thursday webinar. My name is Chris Wager with M&S Shuster, and before we get started, a couple housekeeping items that I want to mention. First, the webinar is being recorded, so it will be made available at a later date for you to view another time or to share with your friends and family. It will be on our website. In addition, during the webinar, please feel free to use the question and answer function on Zoom to submit questions. We're not sure if we'll be able to have time to answer those at the end of it, but in any event, if you do submit a question, we will be sure to follow up with you afterwards if we're not able to get to it at the end of the webinar today. It's a quick 30 minutes, so hopefully we can get you a good amount of information in that time. So again, thank you for joining us. The topic of the webinar today is think your leads are TCPA compliant, not so fast. Kind of like that, not so fast there. There's a lot to think about here, and hopefully, as I said, we'll be able to go through that. Again, my name is Chris Wager. I am a partner here at M&S Shuster. I work both on the litigation and the compliance side, so I have the unique perspective of working with clients both on compliance issues, but before any issues arise, and also from the litigation side to see where people get into trouble and where we can improve. So and before we get started, again, the disclaimer, I'm sure you guys are frequently familiar with these at the beginning of webinars. The purpose of this webinar is for informational purposes only. It is not legal advice. And if you do have specific legal questions, please feel free to contact us or other lawyers for specific legal advice. So today, we're going to go over this in three parts. First, what I'm calling the myth of a TCPA compliant lead. We will get into that. The action item, which is going to be how to align leads with your actual calling or texting practices. And third, to address some common issues and questions that come up in the lead generation and lead use space. So beginning, what I'm calling the myth of the TCPA compliant lead. Using myth here, I'm being a little bit tongue-in-cheek. We're going to discuss today, there are a number of ways to really reduce your risk and to be on the safe side of compliance. However, there is a lot of misunderstanding out there where people think that it's a black and white question as to whether or not TCPA leads are compliant, and that's what we're going to be addressing. Where the quote unquote TCPA compliant lead, there's no such thing there. It's a gray area, and that's why it's important to look at your lead sources and your calling practices and to align them so that in practice you are actually acting in a compliant manner. So stepping back really quick, when we talk about what a compliant lead is, in very broad brushstrokes, a compliant lead accomplishes two things. First, what it will do is it provides consent. That's both under the TCPA and under various state laws that have requirements in order to use certain technologies in the outbound calling. And that can be the use of an auto dialer or pre-recorded voice. Now, it's important to note that while a lot of restrictions under the TCPA and state laws apply to marketing calls, the need for consent in this area can also apply to non-marketing calls. In addition to consent for that technology, generally speaking, as I'm sure many of you are aware of, state and federal do not call registries can limit your ability to make marketing calls to consumers who have listed their name on those registries. And the goal there, short of scrubbing your list against any residential or wireless numbers that are registered on those lists, is to create an exemption. And that can be done using what we call an inquiry EBR, existing business relationship or consent. And that's hopefully through the lead generation process, we are sufficiently creating that exemption so that the calling business is able to call individuals that are on those lists and not have to worry about scrubbing against those lists, which can severely limit your ability to contact interested consumers. So really the genesis for the webinar today and what I'm thinking about is so many times in the past few months, I've been looking in the space and seeing in general people touting quote unquote TCPA compliant leads. So you see marketing materials on websites where people say comments like I've listed here, our leads are 100% TCPA compliant. At the same time, I've even seen in written contracts, a lead seller is putting in a representation or warranty or assuming liability, simply stating that their leads are going to comply with all applicable laws. And usually applicable laws is a defined term, which is going to include the TCPA and other telemarketing laws. So really, we're seeing these absolutist statements just stating the lead is TCPA compliant, and that's all the inquiry that's done on the matter, and everybody moves forward. So you're probably saying, well, what's the problem with that? Isn't that great that the leads are compliant? Well, the problem is it's not that simple. And the important thing is, the next point that we're going into is that the lead itself and the consent that is gathered on the lead and the inquiry EBR, the consent that's generated through it really needs to match the subsequent call that is relying upon that lead. And one of the big, and here I have at the headline, we say context is king. And the phrase that I'm going to go back to a number of times is this idea of scope of consent. So the purpose of a lead is for the consumer to agree to and consent to receive the call in question. And so I have an example here. If you have a TCPA, or I'm sorry, a lead generation form where above the submit button you have language such as I consent to receive 3 auto-dial calls per week about health insurance offers. Well, when you're looking at that lead, some questions pop into your head. Well, who's going to be calling you? Are they going to be sending you text messages? What about the use of pre-recorded messages? What if the caller calls you 5 times instead of 3 times a week? What if the end seller calls and instead of just offering health insurance, they offer you auto insurance? Is that within the scope of consent that is offered or that is provided by the consumer? If it's not, then there's serious questions about that lead and whether or not that granted the consent needed for the caller either to use technology like an auto dialer, a pre-recorded voice, or to call someone who may be listed on a do not call registry. Thinking about scope of consent, it reminds me kind of the example I like to fall back on is it's kind of a war story is that, I'm familiar that there was a TCPA case where a seller received consent and where the reason why I put 3 calls per week on there as an example is they received valid consent to call a consumer 3 times a week. Well, around Thanksgiving time, they called a consumer, 3 times the week of Thanksgiving, 3 times the week after Thanksgiving. It seems fine. However, a TCPA suit, the class action suit was brought alleging that, well, during that week on the Wednesday before Thanksgiving to the following Tuesday, actually there were 5 calls there. So therefore in that 7-day period, I received 5 calls instead of 3. Therefore that, again, going back to scope of consent, that exceeded the scope of consent that I provided. And that person, they were able to maintain a lawsuit making that argument. So that's why it's important to look at that. Just like 3 calls versus 5 calls can be an issue, if you're not identifying the right seller by name, that can again be outside the scope of consent. So it's really important to think about, is the consent that's provided, does that allow the call? So really, at the end of the day, the litmus test, the question that, the first question to ask is, based on that lead form, is the consumer, will they be expecting a call from me, the seller, on the topic that I am calling them about and in the method that I am calling them? That's what we're talking about. We're talking about aligning the lead with the call practice. The lead has to be tied to the actual subsequent outbound calling that is occurring as a result. So to do this, really, there's two aspects here. Aligning the calling with the lead serves two purposes. First, it protects the lead buyer. And really what you're going to want to do is, hopefully in the lead purchase agreement or some addendum, you can have some written terms in here that can protect you as the lead buyer. One, it's good to outline the standards and the elements that are in the lead form. So again, we made the comment about, calling versus texting. Pre-recorded voice uses an auto dialer. If you are, looking at your anticipated calling campaigns, make sure that you're requiring the lead seller to provide you with leads that are going to allow you to make the calls in the way that you plan on doing so. In addition, on the lead form, and we're going to get into this topic later, I know we've already had a number of questions about this, does the at the end of the day, the lead buyer, the party that's going to be calling the consumer, do they need to be listed on the lead form? And we'll go into that in a little more detail later about putting them on the form versus a linked marketing partners page, so on and so forth. But we'll talk about that. But consider making sure that you are specifically identified as an entity that will be calling the consumer. In addition, to protect yourself as a lead buyer, you want to consider restricting the use of higher risk lead sources. This can be the websites that have sweepstakes, an offer to get a $100 Amazon gift card. Those types of sites create more risk. Really, at the end of the day, the more targeted the lead source is. So if it can be tied to your industry vertical, for instance, if you're selling insurance, at the end of the day, you're going to see less TCPA risk if someone is going to a web page where they're making a specific inquiry about insurance products rather than entering into a raffle or sweepstakes or just general or submitting a claim to something that's unrelated to insurance. So really tying that to there. And again, that goes back to the point before about a litmus test is, does the lead form, does that give the consumer the reasonable expectation that you will be calling them? Clearly, if someone says, hey, I need some information about insurance, then that shows that, that in all likelihood that they would be expecting a call about insurance. In addition, one other thing to think about, is we see a lot of affiliate networks, and we see a lot of leads that are passed down a chain in a number of steps. So consider, based on your risk profile, whether or not you want to, if you are buying a lead, whether or not you want to require the lead seller to generate the leads that they're providing you in-house, just to take out some additional layers that you may not have transparency for. In the alternative that if you are going to be using a lead seller who's using affiliate networks or otherwise obtaining the leads from other publishers or other sources, it's good to seek transparency. Require that you get some insight into what the lead forms look like. I know in an area that can be a challenge because a lot of lead sellers treat that information, the ultimate source of their leads, as proprietary, and that's not something that they necessarily like to share. However, for you, the entity making the call, I think it makes a lot of sense, to lower your risk to be able to to ask that question. And if the lead seller is hesitant to do that, feel free to reach out to us, because we have some some ways that we can work with you to hopefully get you some transparency that may also address the concerns from your lead sellers about providing that what they consider proprietary information to you. And I do want to point out, we're talking about this in the context of lead buying and lead selling. A lot of these concerns also apply, if you're making outbound calling, if you're generating the leads yourself. You have to ensure that the leads that you're generating are consistent with your calling practices. What we see, what we have seen in the past are, entities that are making outbound calling, they generate leads internally for a specific purpose, then they add them to their CRM database, and then they're just in there for years, and we'll market to those numbers. Well, you need to go back and look at what the initial source of that lead was. You could have grandfathered lead generation that's no longer consistent with your current calling practices. For instance, maybe you have a new affiliate that's calling under a different name that wasn't on that lead. Maybe you're entered into a different vertical where that initial lead that was generated a year ago for consumer, they signed up because they wanted a home warranty product, but now instead, you're selling a commodity. And in those different verticals, so then they're going to say, well, the scope of my consent was to get calls about home warranty and not the other issue. So you really, even for internally generated leads, need to look back and ensure that the lead that was generated and the scope of consent that was provided matches the calling that you're going to subsequently perform for that. And again, stepping back, TCPA compliance it's a continuum of risk. And there are different business needs that lead buyers have, and you really just need to. It's the transparency and the understanding of where you are, so you can make that determination in terms of what lead practices, and potentially what areas of risk are going to be acceptable and you're willing to take on. But in order to do that, it does require a more intensive process of actually understanding the leads that are being provided, and customizing those to your needs, so that you can really make an informed decision about the risk that you're taking on with your leads. So in addition to protecting the lead buyer, having this foresight and insight into the leads and what the calling will be also protects the lead seller. And this can fall into context two places. So, a lead seller, a lot of times we see that lead sellers assume some or all risk with TCPA compliance. In addition, lead sellers, in addition to just selling the pure calling list, can do some outbound call or texting in order to pre-qualify someone. And that could either end in, scrubbing it and to provide a pre-qualified list to an ultimate seller, or it could involve, pre-qualifying and then doing a call transfer. Now that you are, as the lead seller here, placing the outbound calling, there is some risk that the subsequent telemarketing activities of the ultimate seller, the seller to the consumer, their actions can extend some liability to you. So it's important. There are a number of instances where a lead seller, can assume risk. And I do want to point out that in addition to contractually accepting risk for the sales via, an express indemnification clause, there are state laws out there that provide for common law indemnification. So even where you may not necessarily be accepting contractual liability, there still are areas where a party that ultimately receives a TCPA demand could make an indemnification claim under the common law. So there is always risk in selling leads, even if you're not making the calls yourself. Now, in a lot of places, the risk for a seller, a lead seller, in connection with the leads, can arise from, if a lead buyer has an unanticipated use of the lead. So if they're, if they're selling the leads to another source in a different vertical, if they're cross-selling a different product that you weren't anticipating, or using other technologies, you could have contracted with the lead buyer, understanding that they were going to be engaged in a calling campaign, but at the end of the day, they're texting instead. And so therefore, if you're just generally, like we said before, if you're repping and warranting that all leads will be compliant, well, they're compliant for a specific purpose. So what you want to do is understand what uses your lead buyer will be, what their calling practices will be, and ensure that any representation that you make or your lead practices are consistent to allow that anticipated calling practice. And instead of, generally speaking, repping and warranting that leads are 100% TCPA compliant, specify that rep and warranty to, into who will be making those calls, how they're going to be making the calls, what purpose they'll be making the calls. So you want to specify stating, our leads are compliant to allow XYZ Corp to send, automated telephone calls to customers to sell ABC product. That type of language insulates you, because what you're doing is you are providing a reprimand warranty to a specific call type that you anticipate happening, and you're limiting that again so that there's not going to be unanticipated uses that you don't understand. Takeaways here. Again, the point is really aligning the leads with the call practices. A TCPA compliant lead is not one size fits all. The consent goes towards a specific seller for a specific use and using a specific technology. That is how a lead will be TCPA compliant. It's compliant for a specific purpose. Now, at the end of the day, the best practice here is to formalize this into a contract, these standards, both in terms of how the lead seller will be obtaining the lead and what consent they're obtaining on the lead form, and also then what the calling practices for the lead buyer, how they will be calling them to ensure that those two aspects line up. In addition, the lead buyer, I think it makes sense to for you to review lead submission forms. And what you want to do is, again, apart from what the contract says, in practice, you want to make sure that the language, the consent language, and the overall lead generation form itself captures your anticipated calling. Again, ask yourself, a consumer filling out that lead form, are they going to reasonably anticipate the call that I'm planning to make to that consumer? If not, you need to step back and think about it. In addition to being a compliance issue, I think it's a lead quality issue too. You know, at the end of the day, you want your leads to be you want your calls to be to consumers who express genuine interest in your product. And I think that knowing that the consumer has expressed that interest is only going to help you from a business standpoint in the end. Again, lead seller, be careful about what you're representing about the scope of the lead and understand how your buyer will be using the leads. Again, one of the phrases I've used before, scope of consent. Always think about that. What did the consumer agree to on the lead? And is your calling practices, do that align with what they asked for? Well, we've kind of talked more general or more specifically about, you know, kind of the call list buying lead generation aspect. You know, these principles apply in other areas as well. You know, if you're relying on outside sellers to sell your product, you know, either generate the leads internally or you know, otherwise purchase the leads and make the outbound calling on your behalf. You know, a lot of these concerns transfer there. In addition, if you're accepting lead transfers, that can apply. You know, there is liability issues about if the, especially where the initial call that was transferred to you, if that was an outbound marketing call, you know, even if in the duration of that call, if if that initial outbound caller gets consent for subsequent transfer, there are serious TCPA liability questions as to whether that's valid consent, because that's not consent that occurred before the call occurred. So the transfer and selling an alternate product that may not have been initially consented to could be outside the scope of consent of prior express written consent prior to the call of what the caller or what the consumer agreed to before they were called in the first instance. Again, that inbound outbound distinction, that's important. One area where we've seen a lot of TCPA action is in accepting call transfers, where at the end of the day, a seller understood that their inbound warm lead transfers were inbound calls to the entity that was transferring the calls to them. But lo and behold, we find out at the end of the day that the initial call was an outbound telemarketing call to the consumer, which again, significantly changes your risk profile. With all of these, vicarious liability becomes an issue. So if you're using an outside seller, or there's a question about an initial call that you didn't place but it's then transferred to you, issues of vicarious liability can lead for you to ultimately be liable even if you did not directly place the call yourself. So with that in mind, I kind of want to spend a few minutes to go over some common issues and questions that come up. What we've gotten a lot is, I'm sure everybody's aware of the Facebook decision that time flies, has been almost a year out now, where people say, do I really have to worry about, predictive dialing or an auto dialer after Facebook? And to step back real quickly, for those of you who aren't familiar, the Facebook decision was issued by the United States Supreme Court last April. talking about auto dial calls, which applies to calls and text to wireless subscribers. And what the decision stated was that in order to qualify as an auto dialer where you need consent to make those calls, it requires use of a random or sequential number generator to qualify. And if it doesn't, then consent isn't necessary. Our reading of the decision, which we think is the right decision, is that when we talk about random and number sequential generation, is that refers to the phone number that's called. So what does that mean? That means that the auto dialer restrictions apply to non-targeted marketing calls, right? Where you're calling 555-001, 555-002, or purely random numbers. However, that's not telemarketing practice these days. Especially if you're using a list, we're relying on targeted marketing, targeting calling, which we argue doesn't fit within the new definition as set forth by the Supreme Court. So therefore, if you're not doing a truly blanket calling campaign, then you shouldn't have to worry about whether or not you're using a auto dialer. Well, while we agree with that, the law is not yet settled on that point. Within the past 2 weeks, there was a federal court decision that came out. We were disappointed, but stated that even a targeted calling campaign, that court stated that there was an issue of fact as to whether or not an auto dialer was used. And really, and not to get into too much details, but the plaintiffs bar, what they're arguing is that if you have a calling list, a list will be in order, and they're stating that if you're sequentially calling numbers down the list, then that's sequential dialing, not that you're sequentially picking out a phone number to call, you're sequentially picking out a number from your database. That has generally been rejected, but there are still courts that are accepting that argument, which can open up the door to liability. In addition, if you are placing marketing calls, even if we accept that Facebook has taken away the need for consent, there still are do not call requirements. And so, you still need consent or an inquiry EBR to call people who are listed on do not call registries, either on the state or national level. In addition, various states, many of you may be aware of the new Florida TCPA statute, which also has an auto dialer restriction, but does not contain the random sequential number generator standard that the Supreme Court relied on. So we have been seeing numerous lawsuits out of Florida on this, and there are a number of other states as well that are proposing new laws with a more expansive auto dialer view. So unfortunately, while the Facebook decision was a positive development, the issue has not completely gone away and still bears some consideration. Now, the other kind of the big question, I know that we've gotten some questions in advance of today, and we received this, is the use of a marketing partner on a lead generation form. And that can take place in a number of ways, in what I call kind of a continuum of risk. Your safest bet would be on the TCPA disclosure language above the submit button, the seller is specifically named. I give consent for XYZ company to call me about marketing offers. That is the gold star compliant 100% approach. The kind of the next step that we see, practice we see is a linked marketing partners page, right? Where, you give consent for usually the lead generator and its marketing partners to call, and someone can click on a marketing partners, and there is a list of, varying length that include the party that ultimately could be calling. And, kind of further down the list is just stating marketing partners without actually creating a link and identifying any specific sellers who may be calling. Again, and thinking about this approach, on one level, so, if we are going to deviate away from the 100% compliant, you need to be listed on the lead generation form, talking about this other continuum of risk, my fallback question is always, whether or not the consumer is on the reasonable expectation for that call from that seller. And some factors to think about is, is the lead generation form for a specific vertical? So is the consumer going to be considering or expecting a call about insurance? If it is, that's safer. Another issue is the length of the list. Clearly, a shorter list is giving a consumer greater expectation that one of those names on the list will be calling the consumer. And again, whether that list is limited to a specific vertical is going to be a much safer bet than if you have a list of entities that are selling different products and are completely unrelated to each other. In addition, an area that can lower your risk is on the form is to limit the number of sellers who will be contacting the consumers. And stating that you will be receiving calls from up to 3 marketing partners regarding these products. That will again provide you with some additional protection. However, at the end of the day, if you want to be fully compliant, the unfortunate answer is that a seller should be listed on the lead generation form itself. In order to have that consent, because the question is, did the consumer consent for that seller to call him or her? And really to do that, the seller's name should be listed on the lead generation form. In addition, there are state laws that you have to consider. If we are relying on the inquiry EBR, that states have various lengths for that. In addition, there are state telemarketing registration requirements and additional restrictions for wireless numbers and texting. Generally for telemarketing registration and wireless number texting, typically if you do have valid consent, under the TCPA, that generally meets those standards. However, every state is different, and there are some states, including California, Ohio, Texas, New York, that do not recognize consent as an exception for telemarketing registration requirements. One other issue that I really recommend everybody think about is to use a Vexatious litigator scrub. And that can be done, one or two ways. If you're in the lead buying context, either the lead seller, will have done that, or you yourself, the entity that's going to be making the call, can run that. And I think it's just important when you, go into buy leads to get that understanding. Understand, is your lead seller going to previously scrub that or not? And if not, I would consider doing so yourself. And really the reason there is that, even if every other box is checked, we see so many times where businesses are getting these one-off TCPA demands, right? Where someone sends an email, that form email that we've all seen, where they're demanding $2,000 or $3,000 to go away. The unfortunate reality is, in so many places, in order to defend that and to prove your meritorious claim, it's going to cost a heck of a lot more money than is demanded. And if we can, through that Vexatious litigator scrub, get rid of these repeat customers, because it's the same names we're seeing over and over again, to prevent that from happening. I think that's going to go a long way to help you avoid those meritless TCPA demands that come in, where it kind of puts you between a rock and a hard place about paying these people to go away. In addition, even in class actions, again, repeat customers are doing this. We're seeing a lot of games getting played with lead generation forms, people using VPNs, bots, other technology to get their number on a calling list, where they've used some sort of technology that can, where they think can block them from alleging that it was actually them that submitted the form, despite, you're using trusted form or deny it, using all best practices. So really, given the bad actors out there and their incentives, I just think it makes all the sense in the world to scrub against that. In addition, if you're using leads that are aged a little bit, consider checking those against a reassigned number database. We've seen a lot of action recently with TCPA class actions where they're alleging calls on those reassigned number databases. Again, bad actors, a lot of people out there who are buying numerous cell phones, so they've got a newly transferred number that if they get calls that they didn't consent to, that they're trying to gin up TCPA claims based on that. That is, I apologize for everybody, went about 3 minutes over, but hopefully you found today's webinar helpful. If you have any additional questions, I know we didn't have a chance to answer anything to submit in the Q&A, so feel free to, either if you didn't submit it there, to reach out to me. My information is on this page with any questions, and I look forward to hearing from you. Thank you so much.